What's up, guys? It is the Bad Wolf. Bad Wolf, what's going on? It is time to get into it. We have had such a, dare I say, monumental response to that particular court ruling with the Social Security number and the birth certificate that a lot of people reached out to me and they were like, where's the actual whole court document and this and that? So we have it here for you. Now, once again, I want to give credit where credit is due. So first of all, to Abigail, the young Christian lady who sparked the way for that. Good job for her, and job well done. We need more people like her to start these lawsuits, to go get your rights, and to not be afraid of having what's yours, these freedoms, these liberties, these rights. We need to really push the system back into its box to some degree so that we can live how we want to live as free Americans, not extorted 14th Amendment U.S. citizens. I also want to give credit out for this particular information and the file to Colonel Von Wilson of Copper Moonshine Stills, one of my good homeboys, good friend of mine. He keeps me up on things. I keep him up on things. So shot goes out to him. You guys can find his website and purchase a moonshine still. Yeah, you can say that. I'm thinking. I'm thinking like in the old days where like it was like illegal. I was like, should I say it? It's so funny how so many things have changed and you guys are a part of that change right now. If you're watching this, we're making history right now. It's not just me, it's not just Colonel Von Wilson, it's not just, certain other people out there. But to all those people, sovereign living, living in the private, um, TJ, Mars, the Lighthouse, um, Mr. McDonald, and all the other people out there, especially the ones who, you know, um, support me, watch these videos. Thank you guys, past, present, and future, for the ones who paved the way, those of us who are doing it now, and those of you guys who are going to take this and actually change the future. We're changing the now so that you guys can change the future. All right. So without further ado, let's get into it. As always, guys, just a couple of things. Black Side 32 is doing really good. We've got between 400 and 500,000 visitors, guys. That's insane. I still don't see how I don't have that same type of subscription on my YouTube channel. I don't know, but that's crazy. But still, yet that is powerful. Never thought my site would be doing stuff like that. Like I didn't expect to be doing this in all honesty. Thought it'd be cool, but wow. Okay. Um, JamesCLovett.com has one or two free streaming videos on there, so I suggest you guys go and check those out. And otherwise, we do have the paid ones there, but there's a lot of good little informational bits, is all I'm going to say, guys. When you got gold, you don't need to sell it. All right. You don't see commercials for gold and you don't see commercials for Lamborghinis. Why? Because gold sells itself, and anybody who can buy a Lamborghini is not at home watching TV. So go get your freedoms, your rights, and your liberties. Check out blackside32.com and jameslovett.com. All right. As always, if you guys see anybody using any of my logos or my beautiful punum and doing anything negative, report them for bullying, slander, defamation of character, et cetera, et cetera. Thank you in advance. Now, without further ado, let's chickadee check out the document. Um, I should have a link to this document. All right. And it is by govinfo.gov. We'll break that down in a second. I don't want anybody thinking that this is just something I made or it's a deep fake. It is literally right on the government's website, but you got to know where to get it. So I'm going to make a link at the end of the video because of course I want you guys to watch my video on it before, going to the file. And then if I remember, I'll have a copy of it on Black Site 32 on page 2 of the free documents. Okay. Literally, if you're watching this, I just made this video today, probably an hour or two before you guys are singing now. So shit's hot, son. All right, let me share the screen here. Okay, you guys should be able to see that. Close that up. All right. I'm not going to read through the whole everything up here, but it's basically govinfo.gov/content package U.S. courts. You can use that to find it online. Otherwise, the link will be at the end of the video, and if I'm really good, I'll have it in the description below. Um, and then for those people who are on their TVs and you can't just click the link or go into the message, like I said, the link will be at the end of the video. I'll make sure it's in there somehow. It'll be in the description. The file will be on blacksite32.com on the free document page number 2. Yeah, let's get into it. All right. So, United States District Court. Okay. So this isn't the regular one. This is the superior courts, not the inferior. And it's for the District of Columbia. Abigail Carmichael Jordan is the plaintiff. So she's the complainer. And she's going after Mark Rubio in his official capacity as Secretary of State et al. He's the defendant because he's ultimately the one responsible for the Department of State's, passport. Now, some people asked, they're like, you thought the other guy was there. I can't think of his name. He's been replaced. So poor Mark. I mean, he jumped right into office and he's got a lawsuit waiting for him. So, like, I don't know. It takes a certain kind of person, I guess, to want to be in these positions or whatever else. But anyway, so if you guys want to look it up, it's case number 1:CV-01844 TNM. Okay, if you want to look it up. So now let's get into it. And hold on. Sharing the screen. I got to share the sound. Almost messed it up. I would have had all y'all in the comment sections and blowing up my phones and stuff. You didn't have the phone, you didn't have the volume on video. So we avoided that. All right, like I said, I'm doing it on a fly. I'm not so polished as some
Abigail
people.
Jordan has been trying to get a passport since 2019. The problem? A passport. Application requires either a birth certificate or a letter confirming that an applicant lacks one. And it is Jordan's sincerely held conviction that obtaining either form of documentation would endanger her religious scruples. The predicament has left Jordan dismayed. She feels called to evangelize worldwide, but does not want to sully her other beliefs to do so. Seeking resolution, she sued the Department of State and Secretary of State, collectively the department, asking the court to declare she is a U.S. citizen and order the issuance of a passport.
Now, for me, what I would have had done in here if I was her, I'm glad she won anyway. I would have had it where it said declare that she is a national under 8 U.S.C. 1401A or 8 U.S.C. 1101A 22B. That's what I would have done. But hey, she got the job done. No shame in the game.
Jordan originally filed pro se, and the
Once again, pro se. I mean, unless they would have denied me, I would have went sui juris or pro per. But hey, once again, it's getting the job done. So let's light the fires and kick the tires.
circumstances on the ground remained stagnant. But once the court approved Jordan's request for counsel, the department's whistling took on a different tune. State and federal officials suddenly cooperated to attain the proper documentation for Jordan in a manner that did not violate her religious beliefs. And the department represented that it stood ready to issue Jordan a passport, so long as she filled out yet another passport application and submitted yet another photograph. Now, the department insists the case is moot. Case 1:24 CV 01844 TNM Document 48 filed July 29, 25 page 2 of 26. Not so. Jordan continues to suffer consequences from the department's years-long refusal to issue her a passport.
So really, like I've been saying since day one, if it's a right you have and there's no law against it, um, it's an unenumerated right. Just like me attempting to separate the straw man from the living me by getting a passport done in my private faith-based name or my given name versus a legal name. Those two really should be separated. So it may take me suing them to get it done because they do not have clear information, and all they want you to do is to go to the court to get a name change document. I shouldn't have to go to an inferior foreign court to the United States of America as a grown ass man to declare to them that I am changing my name. I should just be able to do that through either an affidavit or explanatory statement or whatever else. You're denying me of my right. So you're saying somebody who gets married can go to the inferior courts, get their name change document, and then have a different name change on there, but that represents a legal name. I don't want a legal name on my passport. I want my given name. My legal name and given name should be two different things because the legal version of me is a creation of state and law. I am the real thing. Those should be two separate things unless I choose to merge them. But see, we know that this is obfuscation. This is a form of identity theft. It's a form of fraud because they want us all to operate as that 14th Amendment U.S. citizen. Now, I'm not saying all of them, I'm not saying all of the Department of State by no means, but I'm just saying the system has its tentacles in everything on some P. Diddy style shit. Take that, take that, take that. That for them, it is in their best interest to have us as low as possible. They don't want everybody running around as nationals and internationally protected persons under 18 U.S.C. 112. Our natural birthright, our freedoms under the Constitution for the United States of America. Let's get it.
Passport. So much is obvious, she still lacks a passport. The court thus delves into the merits of Jordan's claims and finds that she is entitled to summary judgment on them. As for Jordan's religious freedom claim, the department imposed a substantial burden on her religious exercise when it demanded she obtain documents through a process that violated her religious beliefs. But the department has not presented a compelling justification to require Jordan to go through such a process. Nor has it demonstrated that the process was the least restrictive means of achieving its national security interests. So on that score, the court will grant summary judgment to Jordan. More, Jordan merits summary judgment on her claim under 8 U.S.C. Section 1503. She has.
Okay, so for those who don't know that code off the top of their head like I do, this is denial of rights and privileges as a national. Now, there's more to it, but that's primarily what this code is. So up here, where she's saying I'm a U.S. citizen, I would have put national here. I want mine done as a national. I want them to prove it. I want them to show me, give me my right. But remember, underneath 8 U.S.C. 1101, 22A and B, all U.S. citizens are also U.S. nationals, but not all U.S. nationals are U.S. citizens. So she's not wrong, but the better way to have done it would have been to declare it right there as a national, and then with that, force them to stamp her book as a national with the 09 code. Like Gem Drops, for those people listening, Gem Drops knocks over the trunk with gold and gems in it. Ting, 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 ting.
Made an unrebutted prima facie case that she is a national of the United States entitled to a.
Now, why would she say that? Because as a national, okay, so prima facie means on first glance. So she's saying that she's a national and she's entitled to a passport. And nationals, unlike 14th Amendment U.S. citizens, now understand that we have both. 8 U.S.C. 1401A states that nationals and citizens at birth, national comes first. Why? Because we received that first. That is an act of God. That is a birthright to the land. Then by law, man-made, which is inferior, we were then given the ability to represent ourselves. Well, we as living people are already in the present, but to represent ourselves as that 14th Amendment U.S. citizen, ens legis, legal person, straw man, nom de gore, war name, legal thing. So we have both. One is who we are, and the other one is what's attached to us, like a mask or a suit of armor that has our name on it. It's a jumpsuit. Comes with a social security slaves social slave number, the SSN. You have to put that suit on to go mine in hell. Work the plantation, pick the cotton, Mazel. But as a national, we are their boss. You can't tell me I have to have 14th Amendment U.S. citizen shit. You cannot. The creation, which is all of them, the inferior courts, the superior courts, police officers, judges, lawyers, all that, we put them in power. We are governed by our consent. That means at any point in time, we can revoke said consent. We are the creators. They and it is the creations. The creation cannot be more powerful than the creator. That is God's law. But if you lose yourself into being a citizen, then you shit's weak. Shit's weak. So she knew what was going on. I would not be surprised if this lady was watching my videos. Most people do not speak this way. And Abigail, if you are out there and you are watching my videos and you in fact did learn this from me, holler at your boy. I'd love to have you on my channel. That'd be cool. All right. So a shot goes out to Abigail Carmichael Jordan. I know you're out there somewhere. Like I said, most people don't know this stuff. They don't take it to this far. I almost can bet you she watched my videos and heard me saying you need to sue them. I could be wrong. Could be wrong. All right, let's keep going.
A. Passport. This adequate remedy moots her claims under the APA and the Mandamus Act. I. All her life, Abigail Carmichael Jordan has avoided the perceived stain of a social security number, SSN. AM.
Because there's there's no law that says you have to have one. They talk it all up because they want you to register. Then you're a member of theirs. They have access to you. When you're completely private, you are wearing a triple layer gold encrusted body shield made by God. You are damn near untouchable, undestroyable. That's what it means to be a national in this country. But they downplay it. The only people who are supposed to have a social security number are employees of the state and government, or if you're born in the District of Columbia. Those are 14th Amendment U.S. citizens. So anybody in the public, like a police officer, judge, lawyer, whoever, you're supposed to have one. That is a benefit for an employee slave of the system. You are not operating as a national, though you still have it. You are operating as a 14th Amendment U.S. citizen. But that has just become so normal to say, oh, yeah, I'm a U.S. citizen. Well, yeah, they drop off the 14th Amendment part because once again, what is a nut called in Brazil? It's just called a nut. They don't call it a Brazil nut when you're in Brazil. So in the 14th Amendment U.S. slave system, they're not going to say, hey, 14th Amendment slave system employee number 5173215, slave employee of ours. They're just going to let you pull the fraud wool over your own eyes. And then you're walking around with it, not to be weird or perverted, but that'd be like if some people have seen a stack of my t-shirts on there and it literally says you belong to the Badwolf and you come walking by with one of my t-shirts on and I slap your ass. Pap! That ass though. And you're like, hey, whoa, it's my ass. And I'm like, no, that's our ass. Because you're using their stuff.
AM. Compel, ECF number 24, paragraph 3. Her devout Christian faith teaches her that her God-given identity is sacred, and that the allegiance she owes to her government as a citizen of the United States must be subordinate to her allegiance to her Creator. ID. She thus rejects the possibility of being enumerated or marked by the government, such as by
Enumerated, meaning to be numbered. She does not want to be numbered, if you want to look at it this way, Christian based, God based, the mark of the beast, the mark, to be enumerated, to be marked with a number. You can't buy or sell goods without the what? Social security number. In some way, shape, or form, the SS or social Satan security number because it's tied to what? Your bank account through your debit card, your credit card company through your credit card company. Your loan was based on it. Huh. It all kind of comes back there. Maybe the mark of the beast is already upon us and we didn't know. If you're a religious person, if not, still yet, it's a slave tracking number.
obtaining an SSN, as to do so would be treating the government as if it were God. AM. Compel. Paragraphs 32 through 33, citing Revelation 13 verses 16 to 18. Her parents share this belief. ID. Indeed, her parents did everything in their power to ensure that she did not receive a birth certificate when she was born, including withholding her first name from hospital officials, for fear that applying for a birth certificate would result in the issuance of an SSN.
So maybe she didn't get this from me exactly, because it sounds like her parents were already on game, which is remarkable. So see, I told you guys, there's tons of people out there living this life as a private state citizen and national. This is the old way of doing it. It's still here, hasn't gone anywhere. Your constitutional rights are still here. They're in you. You're not using them. You don't know about them. You don't even know about your own power. They can't force you to have those things, and yet they cannot deny you the benefits of the system as a national.
At the same time, Jordan's faith calls her to make disciples of all nations. AM. Compel. Paragraph 39, quoting Matthew 28 verses 19 to 20. To carry out this mission, Jordan has been seeking a passport for 6 years. ID. First, in 2019, Jordan applied for a passport and attached a sworn letter explaining that she lacked an SSN for religious reasons, and that she did not have a birth certificate for fear she could be assigned an SSN if she applied for one. AM. Compel. Paragraph 40. To bolster her U.S. citizenship bona fides in the absence of a birth certificate, Jordan attached several records, including a sworn declaration from her father, a certificate of her childhood baptism, and a childhood immunization record, among others. AM. Compel. Paragraph 41. This was not enough for the Department. AM. Compel. Paragraph 42. Most relevantly, the department stressed that Jordan failed to supply a statement from the appropriate state registrar of records certifying that there is no birth record on file for her. ID. That is, the department needed a so-called letter of no record from Jordan to issue the passport without a birth certificate. See Peak Decla ECF No. 42 to 3, paragraph 9. A letter of no record, letter, is documentary evidence that is necessary to confirm a first-time applicant's claim of non-existence of a U.S. birth record, which is essential in examining the purported citizenship claim of a first-time applicant. Peak Decla paragraph 10. According to the department, the requirement that a passport applicant without a birth certificate obtain a letter of no record is critical in preventing not only identity theft and fraud but is essential in upholding the integrity of a U.S. passport.
Okay, so now legally, okay, and we're going to see what else this has to say. Though they're saying, though she won and she doesn't need a birth certificate, remember, a birth certificate is issued from the state. So her parents have made their own, which is what I told you guys you can do, because that then becomes an original document. So it's not that you can apply for a passport, you don't need any type of birth information. You still have to have it, but you can have one made at home. I've helped people make these, I've made these. You should have your picture on there, birth, weight, date, time, or nativity. Don't call it a birthday, call it nativity. No zip code, put USA, born in Florida as a Floridian, state citizen, 8 U.S.C. 1401A, or whatever applies. I would load it up with all that information. Then make copies, get it notarized, which is technically optional, but if you want it to be taken more serious, I would get it notarized under jurat. I would have at least 2 or 3 witnesses, mom, dad, anybody older than you, especially, or mom and dad when it happens. That's your document.
Passport. ID. One of the most common types of passport fraud includes using fake birth certificates or stolen identities when applying for passports. The letter of no record is a safety precaution to ensure that someone is who she says she is. Peak Deckel. Paragraph 11. 3. Case 1:24 CV 01844 TNM Document 48 filed July 29, 25 page 4 of 26. Aiming to comply, Jordan visited Virginia's Office of Vital Records to request a letter of.
So what they then do, and I'm not mad at them per se, but what it is that they put you through all these hoops. From their perspective, it's to make sure you're not just somebody who came here, created your own document, and then you're getting a passport now. That's what they're trying to prevent is the fraud. And of course, will people still do it? Yeah. But in her case, she wasn't doing anything fraudulent, and she provided them with a affidavit from her parents stating, "Yeah, we swear that this is it's her." So then that should have been the end of the story. But to dick around even more, they were like, "Well, we need a letter of no record from the vital statistics." Okay, so I go there and they say literally we have no record. So if I was a foreigner or um, illegal or whatever else, they're not going to have my record anyway. So that's actually is it's stupid. All they need to do is say, "Hey, we don't have anything on file. Can you send us some school records? This, that, and the others. Plenty of other little things that they can ask for to help determine instead of playing these godforsaken games."
Of. No record. Am. Compel. Paragraph 43. But the office informed Jordan that she could not obtain one unless she filled out a form entitled Birth Certificate Information, which asked for her name. At birth, date of birth, place of birth, hospital of birth, race, sex, and parents' names. ID, Jordan. Decla paragraph 27.
So she went in there physically. If she was smart, she just should have wrote them a letter, but she walked in there. So they're like, "Well, now that we got you here, it's time to make some money." Because I've already showed you guys the videos where they make money on any of your information. Even if the cocksucking hospital decides to go, "Oh, we're just going to put in a blank form essentially for you, but put on there like baby Johnson," that still yet makes them the hospital money because the hospital's getting paid too. Everybody's getting paid but you. Everybody's getting paid but you. Let me say this another way. You're the only one not getting paid out of your own name and stuff. But this goes against her right as a national.
27. Jordan was fearful that the submission of such information could be construed as a request for a birth certificate, or
And
could
that's
otherwise cause the office to create a stand-in record.
and that's exactly what they would have done. And that's most of the time what the hospitals do, even though rarely these days do people at the hospital um, get anybody who doesn't want to give the hospital their offspring's name. And remember, ladies, check out my other YouTube channel, Badwolf Unrestricted. You are not an informant. They want you to put informant on there because that dehumanizes you. It takes your position as a biological mother to your biological offspring down 40 pegs. It means you have less of a claim and right. It means you are basically just somebody who dropped their baby off at their doorstep to become an orphan and taken care of by the system, putting you in second or shared position. So some of y'all out here talking about, you know what, I'm gonna leave it alone. I'm gonna leave it alone. I'm just gonna say you need to know who and what you are, and you need to get some of y'all need to get right. Get this information right and stop waiving your rights. Stop fighting the unless the guy, and just because a guy doesn't necessarily want to do what you say, because let's be honest, if a guy does everything you say, he's a pushover. If he doesn't do anything you want him to do the way you want to do it, when you want him to do it, and how you want him to do it, then he's a narcissist. Okay? No, he's just like you. He's got wants and desires and things. So even if you don't see eye to eye, you guys need to still work together because otherwise the government and the states will split you up, make you enemies of each other, and they are the ones who win, not you, not the offspring, not the baby daddy that you decided to submit to then let him place his man seed in you and create a offspring. Make it make sense, guys. Come on. They're playing you guys. I don't care if you like how I said any of that or not. It's the truth. Tear gone, sad no more. I don't care if it hurts your feelings or anybody's emotions, male or female. It's about the facts. Let's get down to it. Once again, that's why I made Badwolf Unrestricted on YouTube. Check out that YouTube channel because I be going in on everybody. Everybody's feelings are gonna be hurt over there a little bit. Some of y'all gonna clap, and some of y'all gonna be sad, but that's just what it is. It's time for people to stop being all candy and fearful of everything. I'm fit to say it how it is, but let's keep going. We got a lot more ground to cover.
Record. For her containing that same information, which could then be passed along to the Social Security Administration for issuance of an SSN. AM. Compel. Paragraph 44. So Jordan refused to fill out the form and did not receive a letter of no record. AM. Compel. Paragraph 45. Her passport application was accordingly denied by the department. AM. Received a response. AM. Compel. 3 years later, Jordan again sought a passport. AM. Compel. The department why she could not obtain a letter of no record consistent with her religious beliefs. AM. Compel. Paragraph 50. And she submitted more evidence of her U.S. citizenship. Compel. Paragraph 51. But again, her application was denied because she had not submitted the letter. AM. Jordan then brought this suit. Compel, ECF number 1, at 1. She originally proceeded pro se. ID. Upon Jordan's motion, the court appointed counsel 1 and set a briefing schedule. C Min.
Whoa.
Orders December 18, 2024 and January 21, 2025. Jordan's amended complaint brings 9 counts against the department and several Virginia officials, Virginia defendants. AM. Compel. At 1. Broadly. It argues the department and Virginia defendants infringed her right to religious freedom and violated the Administrative Procedure Act, APA. AM. 1. The court acknowledges the thoughtful and zealous advocacy of Jordan's pro bono counsel. 4. Case 1: various forms of relief, including a permanent injunction ordering the department to issue a passport to Mrs. Jordan, or to provide her with an appropriate religious accommodation, a declaration that Mrs. Jordan is a U.S. citizen and is entitled to a passport, and a writ of mandamus. AM. While this suit was pending, Jordan contacted Virginia's Office of Vital Records to request a letter of no record again. AM. Compel. Paragraph 60. The deputy director informed Jordan that the office would not issue a letter of no record because the office located a birth certificate on file with the name Baby Girl Carmichael.
Did I not tell you that's what they do? I'm going through this right now for the first time with y'all. I have not read this all the way through. I'm doing it right now. And literally, what did I say earlier? Is that they'll put like baby girl and then your last name or something like that to still make money off of you. Trash. Y'all ain't seen this? Come on now.
Carmichael. AM. Compel. Paragraph 64. This tracked with an Ancestry.com search that revealed a similar certificate.
So once again, stuff that she didn't even do, they did behind her back. How the hell did Ancestry.com get it? I told you, you got to be careful with these people, guys. Giving them your DNA to find out where your family's all from sounds all cute until you realize that you're giving them access to your DNA profile. You don't think they sell that to, let's just say, interesting individuals, biological companies? Some people have even alleged, if you want to believe in this, don't want to hurt anybody's religious beliefs, but your DNA may not even be on this planet anymore. There are theories out there that there are other higher bidders out there, we'll just say, not from this planet. Believe what you want to believe. I'm just telling you some of the things I've heard in the back channels. Your DNA is valuable. You guys don't even realize. Maybe just some spit or hair sample to you, but and they give you a cute little, oh, you're from Argentina and Paraguay and okay.
Certificate, which the parties learned about during this litigation. See Admin R. ECF number 42-2 at AR 010. While it is unclear how this partial birth certificate was created, Jordan has her suspicions. When she was born, healthcare providers ignored her parents' pleas to avoid collect DNA or any information from Jordan. That could then be transmitted to the SSA under the Enumeration at Birth program, the way newborns obtain an SSN. AM. Compel. When they removed Mrs. Jordan from her hospital room in the middle of the night and drew blood to record her DNA ID. These same providers also initially stated that Mrs. Jordan could not be taken home until her parents provided her name for birth records, but ultimately relented. ID. Still, this sequence of events likely resulted in the creation of a partial birth record
Which is against
for
her
Jordan,
rights,
which she
what they
never
did.
knew existed until now. Meanwhile, the department and Virginia defendants cooperated.
But see, it's not actually her because her name isn't baby girl Carmichael. That's fraud. It's not her. And all she has to do is say, that's not me. The names don't match. That's not the name we gave our offspring. But once again, then you have to go and attack that. You see how they do it?
Cooperated behind the scenes. In February 2025, they broke major news to Jordan and the court. The Virginia Office of Vital Records decided to forward the letter of no record to the department, obviating the need for Jordan to fill out any offending form. Dep. 5. Case 1:20, paragraph 99. Jordan then voluntarily dismissed her claims against the Virginia defendants with prejudice. Not voluntary dismissal, ECF number 36. As the deadline for Jordan's summary judgment motion loomed, the department informed Jordan that the letter of no record satisfied the documentary requirements for a passport. Dep. S. reply to PLSSTMT Material Facts paragraph 100. So it told Jordan that it would issue her a passport if she submitted a new application and current photograph. STMT person of 10.
Come on.
10. But Jordan remains unsatisfied. She has refused these offers, arguing that there is no sound reason why she should have to fill out another application to receive her passport.
Well, and she would be correct, but to a degree, because from their perspective, if 2 or 3 years have passed, they want a current picture of you. They do have the right to ask for that. Sure, you may not have changed too much within that time frame. So I'm still on her side, but I understand their logic in that.
PLS. Reply BR ECF number 43 at 35. She also fears that this situation could repeat itself upon her. Inevitable passport renewal in a decade. PLS reply BR at 38 to 40. More, she notes that the department could revoke her passport at any time and require her to submit a new letter ID. She sought a judicially enforceable consent decree from the department, offering to terminate the litigation if the department signed on, but the department rebuffed that request. ID at 43. So Jordan proceeded to move for summary judgment against the department, filing the present motion. The department responds with its own motion to dismiss or, in the alternative, cross motion for summary judgment, contending that the case is moot and that, if not moot, Jordan's assertions founder on the merits. The court held a motions hearing and is now set to rule on the cross motions. 6. Case 1:24 CV 01844 TNM Document 48 filed July 29, 25 page 7 of 26. 2. If a suit is not a case or controversy under Article 3, the court lacks jurisdiction to hear it. North Carolina v. Rice, 404 U.S. 244, 246, 1971. So when a party moves to dismiss for lack of case or controversy, such as by claiming the dispute is moot, the court evaluates that claim under Federal Rule of Civil Procedure 12, B. 1. Zuckerman v. U.S. Postal Serv. 961 F.3d. 431, 441, DCCIR 2020. While the court will accept factual allegations in the complaint as true, those allegations will bear closer scrutiny in resolving a 12(b)(1) motion than in resolving a 12(b)(6) motion for failure to state a claim. Nepal v. U.S. Dept of State, 602 F. Sup. 3D 115. 123, DDC 2022, cleaned up. And the court may consider materials outside the pleadings in deciding whether to grant a motion to dismiss for lack of jurisdiction. Jerome Stevens Farms Inc. v. FDA, 402 F.3d 1249, 1253, DCCIR 2005. While usually it is up to a plaintiff to show that the court has jurisdiction, Lujan v. DEFS of Wildlife, 504 U.S. 555, 561, 1992, it is on the defendant to establish that a once-lived case has turned moot. West Virginia v. EPA, 597 U.S. 697, 719, 2022. This is a formidable burden. Friends of the Earth Incorporated v. Laidlaw en Vite Sauves. TOC, Inc., 528 U.S. 167, 190, 2000. A party is entitled to summary judgment if it shows that there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. Federal Art Civ. P. 56a. At the summary judgment stage, the court must examine the facts in the record and all reasonable inferences derived therefrom in a light most favorable to the non-moving party. Robinson v. Petsat, 818 F.3d1, 8, DCCIR 2016, cleaned up. This mode of analysis serves to separate the jury functions of making credibility determinations, weighing the evidence, and drawing legitimate inferences from the facts from the district court's role as the arbiter of legal questions. ID, cleaned up. When parties file cross motions for summary judgment, each 7. Case 1:24 CV 01844 TNM Document 48 filed July 29, 25 page 8 of 26. Motion is viewed separately, in the light most favorable to the non-moving party, with the court determining, for each side, whether the Rule 56 standard has been met. Atiba v. Jean-Pierre. 706F, Sup. 3D 63, 74, DDC 2023, Aft Sub Nom, Atiba vs. Levitt, 133F.4 Th 114, DCCIR. 2025. 3. The court begins as it must with jurisdiction. And it concludes that the department has failed to satisfy its burden of showing mootness. The court thus proceeds to Jordan's substantive claims and concludes that Jordan is entitled to summary judgment on them. A case turns moot, and thus falls outside the auspices of Article 3 when the issues presented are no longer live or the parties lack a legally cognizable interest in the outcome. Already, LLC v. Nike, Inc., 568 U.S. 85, 91, 2013. In other words, the mootness inquiry asks whether events subsequent to the filing of the complaint have so transpired that the decision will neither presently affect the parties' rights nor have a more than speculative chance of affecting them in the future. N.A.M. Butterfly Association v. Wolf, 977 F.3d 1244, 1258, DCCIR. 2020, a defendant bears the heavy burden of showing that a live controversy has expired. ID. Still, there is a wrinkle in this general rule. If the controversy's expiration stems from the defendant's voluntary cessation of allegedly illegal conduct, the tribunal is not deprived, d. of power to hear and determine the case. Los Angeles CNTY. 5s Davis, 440 U.S. 625, 631, 1979. In other words, a defendant cannot moot out a case by shaping up once it gets sued. Otherwise, the defendant could go back to its old shenanigans once the court got out of the way. This is known as the voluntary cessation exception to mootness. 8. Case 1:24 when a defendant argues a case is moot because it has willingly stopped the challenged conduct, the defendant must make two more showings to prevail. First, it must show that there is no reasonable expectation that the alleged violation will recur. ID. And second, it must show that interim relief or events have completely and irrevocably eradicated the effects of the alleged violation. ID. The department has not satisfied this arduous burden. To begin with, the court affirms that this case is best understood under the voluntary cessation framework. The department argued to the contrary at the motions hearing, contending that it is not the department which voluntarily ceased unlawful conduct, but rather the state Office of Vital Records. HRGTR 35:2023, that was an issue between plaintiff and Virginia. It wasn't a situation that could be controlled by the Department of State. The department, the argument goes, has required a letter of no record all along. Now, with the letter in hand, it is prepared to issue Jordan a passport. According to the department, it is the state office that suspended the requirement that Jordan provide personally identifiable information in order to obtain a letter of no record, by ultimately giving that letter to the department of its own volition. Thus, any doctrine that contemplates the department ceasing challenged conduct, the argument proceeds, is inapt here. The court sees things differently. Before this lawsuit was filed and counsel was appointed, the department was adamant that Jordan herself supply the letter. See Admin, Art at AR008, AR. Department shifted course, initiating efforts to independently obtain the letter from Virginia's Office of Vital Records. 9. Case 1. And in an effort to resolve this matter, undersigned counsel certifies to the court that he worked with the Virginia defendants to obtain the letter of no record. Jordan's contemporaneous efforts failed. Her counsel wrote to Virginia's officials explaining Jordan's religious objections and request, A&G, that the VO-FICE conduct a search of its records and, upon confirming that no birth record exists for Mrs. Jordan, provide her with a statement of no record of birth. Batista Declarat exhibits ECF number 35-9 at 2-4. Jordan's counsel stressed that he would pursue appropriate legal action if the letter were not provided within a reasonable time. ID at 2. The office responded weeks later by telephone, informing Jordan's counsel that it was declining to issue the letter because the office had located a birth certificate with the name Baby Girl Carmichael. Batista Declarat ECF number 35-8, paragraph 5. And it stated that it could not provide Mrs. Jordan with documentation of any kind unless she apply d. to amend the existing partial birth certificate to add her first name to the certificate.
So here they have a partial one that was put there without her consent. And then they don't want to say they're want to force her to give new information, not of her own, but of her own free will and accord, but they're forcing her to do it. So they're forcing her to do it, trying to, so they can take that and have a full record and make more money on it, or make money on it, either way. So if she does that, that violates her in numerous ways, but also her religious freedom as a national state citizen, makes them money. And if she doesn't, then they're like, well, we're not going to give you one. So they're extorting her. So she could sue for money and damages, but it seems like she's going the more equity route where she just wants them to actually do something.
Certificate. Batista Declarat paragraph 7. Though Jordan's own attempts stalled, the departments prevailed, the office forwarded the letter directly to the department, which then shared it with Jordan and her counsel. HRGTR 31:18-19, I think they sent the letter first to me. Thus, the department suspended a practice which Jordan objected to, the requirement that she obtain and supply a letter of no record. This makes the voluntary cessation doctrine a clean fit. And the department has not met its burden to overcome the voluntary cessation exception to mootness. It starts off well. The department has satisfactorily shown that it is absolutely clear the allegedly wrongful behavior could not reasonably be expected to recur. Friends of the Earth, 528 U.S. at 190. The department's counsel has represented that the department will keep the letter of no record in Jordan's file so her passport will not be 10. Case 1:24 CV01844 TNM Document 48 filed July 29, 25 page 11 of 26. Revoked or ineligible for renewal based on the absence of the letter or a birth certificate. Dep. Guess Reply BR, ECF number 46, at 24. The court credits this assertion, it is settled practice fully to accept representations such as these when determining whether official conduct will recur. DeFunis v. Odegaard, 416 U.S. 312, 317, 1974. See also Porup v. CIA, 997 F.3d 1224. 1232, DCCIR 2021, relying on government counsel's representations in court when assessing. Voluntary cessation exception. More, only a first-time passport applicant must supply either a birth certificate or letter of no record. See Dep des Mots. Some. J. At 10.
Now, what's interesting about that is it says only a first time. So if you go to get your next one or update it, does that mean then that you don't have to put your social in there? But they already have it anyway.
10N.5. So even if the department were to eliminate the letter from Jordan's file and go back on its word, Jordan would still be eligible for a passport renewal. Put differently, there is no basis to conclude that Jordan will ever have to obtain a letter of no record or a birth certificate again. Jordan's arguments to the contrary sound in conjecture. She insists that the department could revoke her passport at any time and demand she provide a new letter or a birth certificate. CPLS reply BR at 38 to 40, HRGTR 9:27. I don't think it is a stretch. But such speculative contingencies do not show that challenged conduct is likely to recur in the absence of evidence that this is a prospect of immediacy and reality. Diffunis, 416 U.S. at 320 N.5 C. Also National Black Police Association v. District of Columbia, 108 F.3d 346, 350, DCCIR 1997. Stressing that plaintiff's speculative fears were a wholly inadequate basis to find a reasonable chance of recurrence. In other words, the department has met its burden to show that there is no reasonable expectation that the alleged violation will recur. National Black Police Association F.3d at 300. Accord Larson v. U.S. Navy, 5. Government's mootness showing where, he requires. 11. Case 1: Plaintiff's fears of recurrence would materialize. The department has met its burden on the first element of the voluntary cessation test, but it falters on the second. Jordan continues to face consequences from the denials of her passport applications. While the department represents that it stands ready to issue Jordan a passport, it refuses to do so unless Jordan submits an updated application with a new photograph. Peak Decla paragraphs 15 through 16. These extra hurdles constitute effects of the alleged violation. Kafafi v. Hilton Hotels RET Plan, 701 F.3d 718, 725, DCCIR 2012. Had the department dispensed with the letter of no record requirement and acknowledged Jordan's copious evidence of citizenship off the bat, she would have that passport now. And she would not be forced to exert more time, energy, and money to obtain a passport that all agree is rightfully hers. The department may think that these are nothing more than to minimize administrative burdens. See Dep des Mots. Some. J. At 22, arguing that this case is not a sound use of counsel's or the court's time. Dep yes reply BR at 23, the idea that the department should have to forego other policies does not preclude the case as being moot. But it does not point to any case law that establishes a threshold for when ongoing harms count and when they do not.
So in other words, they want to be like, well, come on. I mean, why should we do something special for just her? Same thing like that's why they don't like the way we do the passport. Like, oh, come on. Let's just everybody just be a 14th Amendment US citizen for the love of Satan. um, hey, Department of State, you're literally your job is there to please us as nationals. We pay your everything. So yeah, if somebody here is special and we on our own, because no thanks to you, have to figure out how to do a process, or we want our rights or our freedoms, give it to them. It's your job. Your job is not to be like, well, we are a burden. What do you think you're there to do? I mean, literally, a whole section was created, a whole division within the whole thing. You're there for our benefit, our use, our freedoms, our rights, our say so. You're not some autonomous uh, institution. You answer to the people. We are the people.
Further delays and obligations surely suffice. Indeed, in a related vein, the Supreme Court has acknowledged that a plaintiff's request for nominal damages can keep an otherwise moot case alive. Ajuegbenham vs. Preksuski, 592 U.S. 279, 293, 2021, Kavanaugh. J. Concurring. This reflects that even seemingly small forms of relief are concrete and effectuate a partial remedy. ID at 291. Thus, the possibility of their issuance can provide redress to a plaintiff. ID. Similarly, in the standing context, courts have roundly recognized that the amount of economic harm is irrelevant to the standing inquiry, as a dollar of economic harm is still an injury in fact for standing purposes. Carpenters Industry Council vs. Zinke, 854. 12. Case 1:24 CV 01844 TNM Document 48 filed July 29, 25. F.3D1, 5, DCCIR 2017. The Department has not shown the Court why it should depart from these precedents' collective wisdom that so-called minor harms, which still invite judicial relief, keep a suit in the land of cases and controversies. Here, Jordan faces ongoing harms. The Department is making her expend more labor before she can obtain a passport she should have received 6 years ago. CF Span vs. Colonia. Vil, Inc., 899 F.2D24, 29, DCCIR 1990, plaintiffs' concrete drain on their time and resources constitutes injury in fact. Those injuries can be avoided if the court intervenes. C. Infra, Part 3.c. Since an aspect of Jordan's injury persists that can be relieved by an appropriate court order, this case is not moot. Zuckerman vs. United States Postal Serv. 961 F.3d. At 443. The court therefore turns to the merits of Jordan's claims. B. Begin with Jordan's allegations under the Religious Freedom Restoration Act, RFRA. This statute provides that the government shall not substantially burden a person's exercise of religion, unless it demonstrates that application of the burden to the person is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling government interest. 42 U.S.C. Section 2000 BB1. Even neutral, generally applicable laws are susceptible to a challenge under RFRA. Capitol Hill Baptist Church vs. Bowser, 496 F. Sup 3D 284, 293, DDC 2020. Whether the department has violated RFRA thus boils down to two phases. First, the court asks whether the challenged conduct substantially burdened the plaintiff's religious exercise. If so, strict scrutiny applies. For that stage, the court probes whether the imposition of the burden was in pursuit of a compelling government interest. And it queries whether the pursuit of that interest required imposing the challenged burden. This is a stringent and 13. Exceptionally demanding test. Burwell v. Hobby Lobby Stores Incorporated. 2014. Only if the answer to both strict scrutiny questions is yes can the department justify its behavior. Start with the substantial burden question. Jordan asserts that the department imposed a substantial burden on her religious exercise by saddling her with a dilemma: defy her religious convictions or forego a passport. PLS. The department denied Jordan's passport applications because she did not submit a birth certificate or a letter of no record. Admin. ARZ. Due to the unacceptable risk that an SSN will be generated for any individual with birth certificate information on file in Virginia, even when an SSN is not specifically requested. Jordan Decl. ECF. As its application leads Jordan to fear that it could be construed as an application for a birth certificate containing that information or would cause the Office of Vital Records to generate some other stand-in record containing all the same information that could then be transmitted to SSA for the issuance of an SSN.
That is basically what the IRS does as well. If they don't have a record for you, they put in a stand-in record. Now, technically, there's nothing illegal about that, but to me, that's a form of fraud because you're assuming that I'm doing something either taxable or that I want my information to be put on the public side. But from their perspective, they're like, well, but we already have some of your information. And if we have your information, we have the right to believe, because it must be so, that it is for a U.S. citizen. So we can tell you what to do. But they can't recognize and see the national for the most part because they're private. And they can't tell their boss what to do. So they're like, well, I'm not going to assume you're my boss. I'm going to assume you're this punk ass 14th Amendment U.S. citizen thing that I can tell what to do.
SSN. Jordan. In short, the department withheld a coveted public benefit unless Jordan abandoned the teachings of her faith. Such carrot dangling is the classic example of a substantial burden on religious exercise. The rule is black and white: a person may not be forced to choose between following the precepts of her religion and forfeiting benefits, on the one hand, and abandoning one of the precepts of her religion, on the other hand. Thomas v. Rev. BD of Indiana EMP, Secretary Div. 450 U.S. 707, 716-17, 1981, cleaned up. But here, that is precisely 14. Case 1. What Jordan was asked to do. Passport or salvation. Thus she has been made to suffer a substantial burden on her religious exercise. The department's counterarguments fail to persuade. First, the department argues that this case is controlled by the Supreme Court's opinion in Bowen v. Roy, 476 U.S. 693, 1986, and derivatively the D.C. Circuit's opinion in Kamerling v. Lappin, 553 F.3d 669, DCCIR 2008. It is not Begin with Roy. There, A. Father objected to the state's use of his daughter's SSN when doling out welfare benefits. Roy. 476 U.S. at 696, 699. The Supreme Court held that this gripe could not support a free exercise. Challenge. ID at 699. Roy object, ed., to the statutory requirements that state agencies shall utilize Social Security numbers not because it places any restriction on what he may believe or what he may do, but because the use of the number may harm his daughter's spirit. ID. Emphasis added. But the court stressed that he free exercise clause simply cannot be understood to require the government to conduct its own internal affairs in ways that comport with the religious beliefs of particular citizens. ID.
Yeah, that's like basically saying, "Oh, hey, you guys should re-examine yourselves and then see if, like, you guys, if we did, stuff wrong." Yeah, screw her religion. Yeah, I mean, it's like the police investigating themselves. Hey, guys, yeah, did you guys do anything wrong there? That stop right there with right to travel, or that guy of color, or to that lady? Nah, we didn't do nothing wrong. Everything seemed fine to me. I mean, yeah, how how can you ask the robber or the mugger or anything to investigate itself? Really? That's why, like, literally there needs to be a agency that can overhaul, look at, check the finances, check where our money's going, check the constitutional rights of police officers, judges, the Department of State. I mean, whatever. There should be a specific government of the best, brightest people who have either built their own wealth, built their own financing companies, their own banks, and that agency should be the one that has access to 95% of everything out there. I do believe, some of y'all may not like this, that some of our black projects, black budgets, some of that, when you guys start to find out what's really going on, you'll understand why. Some of that should be left as it is for reasons at this time, even though I would like to be informed on them. I'm just saying. But yeah, we should have that in place. I should be able to pick up the phone and say, "Hey, this is what these agencies or officers did," and that should be taken. It should be looked into immediate and taken care of, not backburnered
ID.
and whatever.
Cheekily put, Roy could no more prevail on his religious objection to the government's use of a Social Security number for his daughter than he could on a sincere religious objection to the size or color of the government's filing cabinets. ID at 700. Because Roy did not object to a forced alteration of his own behavior but offered a theological critique of the government's behavior, he could not state a free exercise claim that his family Smith Blackman 15 Case 1:24 CV0 concurring in part and dissenting in part 733 White J dissenting. This did not become a holding of the court because one of the 5 justices believed the question was moot. Roy 476.
Moot basically just means not valid or invalid, useless.
476. U.S. at 714, Blackman, J., concurring in part. Still, a majority of the court saw a clear distinction between a claim based on coerced personal conduct and a claim based on the government's internal procedures. While Roy's claim fell on the latter side of this gulf, Jordan's is squarely on the former. She protests a mandate on her individual behavior, the requirement that she apply for a birth certificate or letter of no record and spur the risk of being branded by the government.
Keep in mind that when they do these things, they can put it under the guise of, well, we need to identify who you are, and it sounds good. And they're technically right. But we also know the street value of it, where it's they're just trying to keep you from getting it because you're getting something special, something different. And that's where it's messed up, because it's a fine line to identify that, because it's your claim. It's hard to prove that that's what they're really doing. Like, I mail in a letter of complaint signed, notarized under jurat, but then the police are like, well, I mean, sure, you sent it, but like, we need you to come into our office and draft the same thing up. Why? If I'm doing everything, and why do I need to actually physically go in there to do that? That doesn't make sense. It's the games that they play.
Unlike Roy, she is not objecting to the government's internal use of an SSN that has already been created. Roy, potential issuance of an SSN. The same conclusion goes for the department's reliance on Kamerling. There, a convicted felon objected to the state's practice of collecting fluid or tissue samples from qualifying offenders to create a law enforcement DNA database. Kamerling, 553 F.3d at 673-74. Kamerling argued that the collection and retention of his DNA information is tantamount to laying the foundation for the rise of the Antichrist, which defied his strongly held religious beliefs about the proper use of the building blocks of life. ID at 674. Following Roy, the D.C. Circuit held that Kamerling did not allege facts sufficient to state a substantial burden on his religious exercise because he cannot identify any exercise which is the subject of the burden to which he objects. ID at 679. Kamerling did not object to the Bureau of Prisons collecting any bodily specimen that contains DNA material. ID. Instead, he objected to the government's extracting DNA information from the specimen. ID. The circuit stressed that he extraction and storage of DNA information are entirely activities of 16. Case 1. The FBI, in which Kamerling plays no role and which occur after the BOP has taken his fluid or tissue sample, to which he does not object. ID. Thus, like the father in Roy, Kamerling's opposition to government collection and storage of his DNA profile does not contend that any act of the government pressures him to change his behavior and violate his religion, but only seeks to require the government itself to conduct its affairs in conformance with his religion.
So, in other words, they were arguing the wrong issues.
Religion. ID at 680. This type of theological critique did not constitute a substantial burden. ID. Again, Jordan's claims are not simply proselytization. Jordan insists that the department has put substantial pressure on her to modify her behavior and to violate her beliefs by forcing her to apply for a birth certificate or letter. Thomas, 450 U.S. at 718. Thus Roy and Kamerling do not dictate dismissal here. Instead, the dichotomy they set up bolsters Jordan's allegations. Second, the department pokes holes in the reasonableness of Jordan's beliefs. It stresses That Jordan's parents could have obtained a birth certificate for her without risking the assignment of an SSN, as the SSA's enumeration at birth program is voluntary. Dep yes mote. Sum. J, at 21 to 22. And it points out that adults face virtually no risk of unwittingly receiving an SSN, as there is no enumeration program for adults whereby an SSN is issued when they request a birth certificate. Dep yes mote. Sum. J, at 22. The department traces the path an adult would have to take to obtain an SSN, which includes fill, ing, out an application for a social security card, forward, ing, it with required documentation to the Social Security Administration for review, and potentially undergo, ing, a personal interview. Dep yes mote. Sum. J, at 22 to 23. Thus, according to the department, Jordan's fears are unfounded. Dep s. Mote. Sum. J, at 24. 17. Case 1:24 CV01844 TNM Document 48 filed July 29, 25 page 18 of 26. The court is disinclined to bicker about the way the system works. It very well may be that Jordan never faced a substantial risk of receiving an unwanted SSN at birth or during adulthood. But for Jordan's RFRA claim, the actual risk is irrelevant. What matters is whether Jordan sincerely believes that applying for a letter of no record conflicted with her faith, because it exposed her to the unacceptable possibility that she would be stained with an SSN. And here, there is no dispute that Jordan honestly believes this. See Dep S reply to PL/SSTMT. Of Material Facts paragraphs 3, 6 to 20. So the court must credit her fears, it may not tell Jordan that she is mistaken about the dictates of her own faith. See John Locke, A Letter Concerning Toleration. 7, 1689 T. He care of souls cannot belong to the civil magistrate, because his power consists only in outward force, but true and saving religion consists in the inward persuasion of the mind. Memorial and Remonstrance against Religious Assessments, 2 Writings of James Madison 183, 184, G. Hunt edition 1901. The religion then of every man must be left to conviction and conscience of every man. T. He opinions of men, depending only on the evidence contemplated by their own minds cannot follow the dictates of other men. Nor may the court draw the line on the near occasion of sin. See Reverend Francis J. Connell, 3 The New Confraternity ed., Rev'd Baltimore Catechism and Mass 42 Quest. 76, 1949. This conclusion is compelled by the Supreme Court's decision in Burwell v. Hobby Lobby Stores Incorporated, 573 U.S. 682, 2014. There, the proprietors of closely held corporations objected to a federal policy that required them to provide health insurance to their employees that covered methods of birth control that could destroy an embryo. ID at 690 to 91. These birth control methods conflicted with the proprietor's beliefs that life begins at conception. ID at 700. The Supreme Court held that the federal law imposed a substantial burden on these plaintiffs. ID at 720. If the proprietors did not yield to a demand that forced them to engage in conduct. 18. Case 1:24 CV01844 TNM Document 48 filed July 29, 20. That seriously violate d. their religious beliefs, they faced severe financial penalties. ID. Such an intolerable choice, according to the court, was a substantial burden on religious exercise. ID. In holding so, the court rebuffed arguments that the connection between what the objecting parties must do, provide coverage of potentially abortifacient contraceptives, and the end that they find to be morally wrong, destruction of human life, was simply too attenuated to constitute a substantial burden. ID at 723. Such an argument, according to the court, dodged d. the question of what RFRA presents, which is whether a government policy imposes a substantial burden on the ability of individuals to act in accordance with their religious beliefs. ID at 724. Instead, the argument address d. a very different question that the federal courts have no business addressing. W. Whether the religious belief asserted in a RFRA case is reasonable. ID. Emphasis added. The proprietors sincerely believe d. that providing the insurance coverage demanded by the federal regulations lay on the forbidden side of the line between prescribed and prescribed conduct. ID at 725. That was all that mattered. It was not for the court to say that their religious beliefs were mistaken or insubstantial. ID. Hobby Lobby controls here. Just as the religious proprietors feared their participation in the insurance program could lead to their facilitation of abortive activity, Jordan fears that providing birth certificate information to the government may catalyze the issuance of an SSN. And asking to be so branded contravenes Jordan's faith. The honesty of this conviction cannot be doubted. Jordan herself was given a partial birth certificate without her knowledge or consent after hospital staff collected Jordan's DNA without her parents' approval. C. Kamikil Dekl ECF number 35-4, paragraph 7. And one of her family members was issued an SSN against his will. Jordan Dekla paragraph 10. Thus it is understandable that Jordan sees the passport application 19. Case 1:24 CV 01844 process as a string of dominoes. And it is undeniable that Jordan views filling out the paperwork as flicking the first domino in the line. That is all a court evaluating a RFRA claim can assess. The department suggests that Jordan's case is different from Hobby Lobby. According to it, in Hobby Lobby, the proponents of the contraceptive mandate were attacking how the proprietors interpreted the tenets of their own faith. Dep Yes reply BR at 8-10. But here, the department does not doubt that Jordan's faith compels her to avoid the issuance of an SSN. Rather, the department only seeks to disprove the secular and factual belief that Jordan faced a risk of receiving an SSN. Dep Yes reply realistic concern. But to deem a belief secular rather than religious is to beg the question. After all, we are judges, not moral philosophers or theologians. This is not a question of legal causation but of religious faith. University of Notre Dame vs. Dissenting, cert. Granted, judgment vacated sub nom. 901, 2015. Faith implicates difficult and important question, s, of religion and moral philosophy that necessarily involve individualistic calculations of tolerable levels of risk and complicity. Hobby Lobby, 573 U.S. at 724. Sure, those calculations will use factual understandings as inputs, but an adherent's ultimate assessment of the risk, and thus her ultimate perceived degree of culpability, is the output, and that necessarily involves faith-based value judgments. 2013, Gorsuch, J., concurring, T. He mandate infringes plaintiffs' religious liberties by requiring them to lend what their religion teaches to be an impermissible degree of assistance to the commission of what their religion teaches to be a moral wrong. In other words, an adherent's understanding of the spiritual consequences of an action, and her own concomitant. 20. Case 1:24 CV 01844 TNM Document 48 filed July 29, 25 page 21 of 26. Blameworthiness is deeply personal and part of her faith itself. It is not the role of the court to correct that understanding by trying to prove her wrong. Even if Jordan is misguided in thinking that the scheme is spiritually risky, had is not the court's call to make under the first prong of RFRA. Priests for Life v. Dept Health. And serves a rehearing en banc. That is, Jordan's legal interpretation of what triggers the issuance of an SSN is beside the point. What matters is whether her participation in the scheme fact. Eternal F. Jordan sincerely believed that acquiring a birth certificate or applying for a letter of no record would violate her religious beliefs. That is where the inquiry stops. Because Jordan was put to a choice between violating her religious beliefs and receiving a passport, she was made to suffer a substantial burden on her religious exercise. That brings the court to strict scrutiny. The department satisfies strict scrutiny only if it demonstrates that application of the burden to Jordan is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling governmental interest. 42 U.S.C. Section 2000 BB1, B. Put differently, so long as the government can achieve its interests in a manner that does not burden religion, it must do so. Fulton v. City of Philadelphia. Meant to be anything less. CIR 21. Case 1. To begin with, the department has not shown that it has a compelling interest in requiring Jordan to supply a birth certificate or a letter of no record. It insists that he letter of no record is necessary to confirm the non-existence of a U.S. birth record and is essential in examining the purported citizenship of a first-time applicant and is critical in preventing not only identify theft and fraud but is essential in upholding the integrity of a U.S. passport. Dep. S. Mote. Sum. J. at 37. Perhaps. But as critical as these generalized interests may be, the department cannot rely on them to satisfy its burden. Capitol Hill Baptist Church. Sup. 3D at 298. Interests and instead scrutison, whether the department has a compelling interest in requiring the particular claimant to satisfy the documentary requirements. Centro. The department does not even mention Jordan while making its compelling interest arguments, instead invoking abstract notions of national security untethered from this dispute. Dep. S. Mote. Sum. J. at 37. The department counters by arguing that it is not at liberty to determine that certain Documents are not needed for some individuals, like Jordan, while requesting them from others. To issue a passport. Dep yes reply BR at 12. But that is precisely what RFRA requires of the Department. 42 U.S.C. Section 2000 BB1, requiring the government to show that the application of the burden to the person furthers a compelling interest, emphasis added, O Centro, 546 U.S. At 431, stressing RFRA's focused inquiry on the asserted harm of granting specific exemptions to particular religious claimants. More, the federal law regulating passport issuance explicitly recognizes that passports cannot be conditioned on First Amendment activity. 22 U.S.C. Section 2721, a passport may not be denied issuance, revoked, restricted, or otherwise. 22. Case 1: limited because of any speech, protected by the First Amendment to the Constitution of the United States. The Department must accommodate when it is necessary. But the Department has not even argued how eliminating the letter of no record requirement for Jordan and only Jordan would undermine its interests in passport integrity. Perhaps this is because the Department could not make such arguments if it tried. Jordan has provided abundant independent evidence of her citizenship. See Admin, R, at AR 0050, AR 034, 047. It is unclear what a letter of no record from Jordan, a document that the Department admits is not directly probative of citizenship, could add to the passport. Adjudication. Dep yes mote. Sum. J, at 41. No one suggests Jordan poses a risk to national security or is engaging in criminal conduct. Thus the letter appears superfluous. It may be a road administrative requirement to the Department, but it carries the threat of iniquity for Jordan. More, the history of these proceedings reveals that requiring Jordan to obtain a letter of no record was not the least restrictive means of carrying out the Department's generalized interests. After some cajoling, the Virginia defendants forked the letter over to the Department without involvement from Jordan. Dep yes mote. Sum. J, at 9. Indeed, Virginia law envisions this circumstance by allowing state officials to provide this information directly to the federal government. See Virginia Code Section 32.1-272, d. Clearly, then, the Department did not lack other means of achieving its desired goal. S. Hobby Lobby, 573 U.S. at 728. While the Department insists that it had no obligation to seek the letter on behalf of Jordan, Dep. S. reply to PLSSTMT of Material Facts paragraph 54, RFRA may in some circumstances require the government to expend additional funds and efforts to accommodate citizens' religious beliefs. Hobby Lobby, 573 U.S. at 730. The Department could have worked with the Virginia defendants from the beginning, thereby eliminating the need for Jordan to pay a 23. Case 1:24 CV 01844 TNM Document 48 filed July 29, 25 page 24 of 26. Spiritual toll. When a potential compromise like that exists, the Department cannot show it pursued the minimally onerous path. The short of it is, the Department imposed a substantial burden on Jordan, and it failed to show that the burden was the least restrictive way of achieving a compelling interest. Jordan is entitled to summary judgment on her RFRA claim. Point 2. C. With the RFRA claim resolved, the court proceeds to Jordan's claim under 8 U.S.C. Section 1503(a). This provision authorizes any person denied a right or privilege by any department or independent agency or official thereof upon the ground that s. he is not a national of the United States to institute an action in the federal district courts for a judgment declaring her a national of the United States. 8 U.S.C. Section 1503(a). This category of right, s. and privilege, s. includes a passport. Icaza v. Schultz, 656 F. Sup. 819, 822, DDC 1987. 2. Prevail under Section 1503(a), Jordan need make only a prima facie case establishing her citizenship by birth or naturalization, at which point the burden shifts to the government to present clear, unequivocal, and convincing evidence rebutting the plaintiff's showing of citizenship. L. Cia v. Tillerson, 865 F.3d 643, 652, DCCIR 2017, cleaned up. Jordan is entitled to relief on her Section 1503(a) claim. The department concedes that Jordan is a U.S. citizen, and Jordan has proffered a body of evidence establishing as much. Peak Decal. Paragraph 15, Admin, R, at AR 030 AR 047. Thus Jordan is entitled to the issuance of a passport, and the court will order the department to provide Jordan with a passport right away. Point 3. 2. Jordan concedes that a favorable judgment on her RFRA claim eliminates the need for the court to opine on her First Amendment claim. HRGTR 18:3 of 5. If you rule on RFRA, it does not need to get into the free exercise claim. The court treats that concession as a voluntary dismissal, given it has favorably disposed of the RFRA claim. 3. Jordan's success on her Section 1503 claim extinguishes her APA claims. CPLS reply BR at 32, conceding that full relief on the Section 1503 claim obviates her APA claims. 5 U.S.C. Section 704, only APA claims for which there is no other adequate remedy in a court are subject to judicial review. More, Jordan has not moved for summary judgment on 24. Case 1:24 CV 01844 TNM Document 48 filed July 29, 25 page 25 of 26. D. A final note on remedy is in order. The court will provide Jordan with the injunctive relief she requests, an order directing the department to issue Mrs. Jordan a U.S. passport forthwith. PLS Prop. Order, ECF number 35-10, at 1. T. He traditional scope of injunctive relief is the extent necessary to protect the interests of the parties. Georgia v. President of the U.S., 46 F.4 Th 1283, 1303, 11th Circle 2022. Any injunction should be limited to the inadequacy that produced the injury in fact that the plaintiff has established, and no more burdensome to the defendant than necessary to provide complete relief to the parties. Gill v. Whitford, 585 U.S. 48, 68, 2018, Califano v. Yamasaki. 422 U.S. 682, 702, 1979. Jordan's harm stems from the department's persistent refusals to issue her a passport, in violation of her rights under RFRA and Section 1503. Absent such violations, Jordan would now have her passport in hand, without the need to shoulder additional administrative burdens and costs. Thus, an injunction directing the department to issue the passport is necessary to remediate Jordan's injuries. Such relief is not unduly burdensome to the department. The most recent photograph and home address that Jordan provided is only 2 years old. The typical lapse between passport applications is 10 years, the duration between issuance and renewal. So the department is not made to suffer unwarranted harm by issuing a passport without mandating Jordan jump through additional hoops that Jordan likely perceives as endlessly proliferating. It is time that the court releases Jordan from this bureaucratic funhouse. Her Mandamus Act claim. Am. Compel. Count 7. But seeing as mandamus also requires a plaintiff to show she has no adequate alternative remedy, Illinois v. Ferriero. 25. Case 1: 24 CV 0-4. The Constitution does not contemplate that judges be spiritual arbiters. If someone sincerely believes she risks her salvation by taking some action, the government may not condition a benefit on her doing so. To find otherwise would be to arrogate an abhorrent authority. The court will not oblige Jordan to follow an agency's assessment of her personal convictions. She is entitled to summary judgment and a passport. Dated July 29, 2025. Trevor N. McFadden, U.S.D.J. 26.
That's it. That is it. Did y'all get that tea? Brought to you by the madman himself, the Bad Wolf. Appreciate each and every one of you guys. Be free in general. Feel free to hit that bell, like, and subscribe. Welcome to the tribe. The truth here will not be denied. God bless America. God bless you. Use this as you see fit. Walk softly, but carry a big stick. I know I do. I'll talk to you guys later. As always, matter of fact, while we were talking, I put this file up on Black Site 32, page 2 of the free documents. It's the very last file on that page. Check out jamesclovett.com for the Living in the Private, some free and primarily paid streaming videos. jamesclovett.com and also blacksite32.com. And for those people who want to see how I talk and how I move in the real world, check me out on my other YouTube channel, Badwolf Unrestricted, where we talk about everything, all things, and we get right to it. We make it hot. Some of y'all will love it. Some of y'all, well, love it. See what I did there? Some of y'all will, and some of y'all won't. It is what it is, but it's just the truth. Now, when I say that, it doesn't mean that necessarily it is God's rule. It just means that these are my thoughts, and they are a combination or a summary of many other people who are good, healthy, and balanced. We're not falling for all this crazy stuff. All right. It's like this. If you're not hurting anybody, you are well off to do and live how you want to. My biggest thing is as long as you have permission from somebody and you're not hurting kids, generally knock yourself out. Okay. But if you are, then that's a problem. If you're denying people their constitutional rights, that's also a problem. But you cannot expect and do not expect me to live in your fantasy world or with your delusion. That is applied from the government to the states to local or nation or worldwide people out there. I'm not going to be a part of your delusion. I will let you have your delusion, but you're not going to pull me into it. I'm good. No, thank you. Okay. So each one of you guys take care of yourselves, live your life the best way you know how. Try to strive to be better every day. Do not fall for the games, the bullshit. Just do your best and be you. I'll talk to you guys later. Thanks for watching.